All right, 1 minute ago, on Tuesday, February 10th, 2026, Trump breaks his silence as Ivanka hits a hard court deadline, and what looks like a family rift turns legal overnight, because in the legal world, silence is sometimes just silence, but in the docket world, silence can be interpreted as non-compliance, and non-compliance is where judges stop waiting and start ordering. At 8:04 a.m. Eastern, a clerk's notice posts to the fictional docket of the United States District Court for the Eastern District of Manhattan scheduling an emergency compliance status conference for 1:30 p.m. the same day. At 8:11 a.m., a sealed attachment is unsealed in part, enough for the exhibit index to become visible. At 8:18 a.m., a short defense letter hits the docket asking for more time. At 8:26 a.m., the judge denies the request in a one-paragraph minute order and keeps the conference on calendar. And at 8:33 a.m., Trump posts his first direct statement in 48 hours, which is what everyone will clip. But the real story is what the court did before he posted, because when the court moves first, your statement is no longer the lead, it's the response. Here's the fast version of the timeline that matters, because this is the spine of the entire episode. Friday, a compliance directive is issued with a firm deadline. Saturday, the defense signals it cannot meet the deadline as written. Sunday, internal family messaging fractures and no unified public posture emerges. Monday night, the moving party files a notice of non-compliance and request for immediate enforcement. Tuesday morning, the judge schedules an emergency conference and orders personal appearances. 3 days. That's all it took for this to go from manageable to urgent. And in this fictional packet, the pressure point is simple. Ivanka is facing a court-imposed deadline tied to surrender, production, or certification. Pick your procedural flavor, but the court's framing is the same either way. You were ordered, you were warned, you were given time, and now the clock is over. That's why the family rift matters, because in high-profile cases, the legal plan depends on coordinated behavior. And when the family can't coordinate messaging, they often can't coordinate compliance either. And judges can sense that faster than the internet can. Quick context in one breath so you're not lost. In this dramatized story, Ivanka is a defendant in a high-visibility matter that blends alleged financial conduct with procedural obligations. Trump is both political force and family head whose public posture influences the ecosystem around the case. And the court, again, fictional, has reached the point where it wants to see whether compliance is real or performative. Now, the hook in the title is Trump breaks silence. Here's why that hook works in this template. The audience assumes his silence meant strategy, but the docket suggests his silence meant uncertainty. And in this story, uncertainty is what turned into legal acceleration. Because on Monday night, the moving party, think prosecutors, a task force, or an enforcement unit in the fiction, files a short notice attaching a compliance log and claiming the defense missed a surrender production deadline without requesting relief in time. That claim triggers an emergency posture, and the judge's first job becomes preventing the process from slipping out of the court's control. Now, let me walk you through the fictional packet the way competitor scripts do, because the structure itself creates credibility even when the audience doesn't read the attachments. Document 1, a notice of non-compliance that lays out the order, the deadline, and the alleged failure. It reads like a checklist. Order issued on date A, deadline set for date B, reminders sent on date C, no completion received by date D. No drama, just sequence. Document 2, a request for immediate enforcement, which is where the moving party asks the court to do something now, issue a bench directive, modify conditions, order marshal-level action, compel sworn certification, or schedule a same-day conference. Document 3, an exhibit index that tells you what kind of evidence they're leaning on: service confirmations, communications logs, travel summaries, device custody forms, and a short declaration from a custodian. And here's what makes this messy in the human way. The packet also references a family witness posture issue, not saying anyone committed a crime, but implying that a close family member was approached to help soften consequences, and they either declined or gave answers that weren't helpful, creating an impression of distance inside the family. That's the rift that turns legal overnight, because courts don't care about family drama. Courts care about whether the people closest to you are signaling reliability or risk. In this fictional script, the moving party points to that distance to argue flight risk, non-compliance risk, or credibility risk, and that's where everything accelerates. Now, I'm going to do the competitor move, and here's the part nobody saw coming. In this story, the part nobody saw coming isn't that a deadline existed, it's that the defense apparently assumed it could be managed quietly, while the moving party treated it as a hard line, and the judge sided with the hard line by moving fast. Because the judge's minute order Tuesday morning uses the language judges use when they're done negotiating. The court requires immediate clarification. The parties shall appear. Failure to comply may result in enforcement remedies. That's the tone shift. And the tone shift is why Trump breaks silence. He senses the shift and tries to reframe it publicly before the court defines it formally. At 8:33 a.m., he posts, he calls the process unfair, he calls the pressure political, he insists his daughter will be vindicated, and he attacks the actors in the system. It's offense, not defense. But here's the catch. Courts don't respond to offense. They respond to compliance. And now Trump's statement creates a second problem. It raises the temperature right before an emergency conference, which makes it harder for the judge to keep the room narrow and procedural. That's why lawyers hate when clients post, because the judge is trying to decide whether today is about a narrow remedy or a broad escalation. And the louder the public conflict, the easier it becomes for the judge to justify tightening control to protect integrity. Now, competitor scripts always include a what the documents show section with pseudo-forensic narration. So here it is in fictional terms. The notice claims the deadline was clearly set. It attaches a proof of service record showing counsel received it. It attaches an internal compliance checklist indicating the moving party offered reasonable accommodations. It references a phone call log where defense asked for informal flexibility rather than filing a motion. And it argues that informal flexibility is not a legal mechanism, only the court can extend. The defense, in its two-page letter Tuesday morning, argues the opposite, that the moving party is weaponizing timing, that compliance is underway, and that the requested enforcement is disproportionate. And this is where the rift becomes more than gossip, because the defense claims it needs time due to logistical constraints, while the moving party claims those constraints were created by late decision-making and internal indecision. In other words, the rift delayed the plan, and the delay triggered the deadline miss, and the deadline miss triggered the judge. That's family rift turns legal overnight in one sentence. Now let's do the pattern section, because competitor scripts lean hard into pattern detection to keep viewers engaged. Pattern 1, escalation through weekends. When filings land Friday night or Sunday morning, it's often because someone wants a Monday reaction. Here, the moving party lands the non-compliance notice Monday night, forcing a Tuesday morning posture. Pattern 2, compressed sequencing. The judge schedules same-day conference, which suggests the court believes delay increases risk. Pattern 3, dual messaging. Trump posts offense. Lawyers file caution. When you see two voices, you're seeing scrambling. Pattern 4, narrowing to certifications. Judges love sworn certifications because they turn fuzzy arguments into crisp accountability. If you can't certify, you either correct or you risk sanctions. So what's the next move the judge is signaling fast? In this fictional story, it's a shift from voluntary compliance expected to compliance verified. That can look like an order requiring a sworn surrender confirmation, an order for an immediate production inventory, an order for passport surrender, an order for limited monitoring, or an order for marshal assistance. The exact tool isn't the point. The posture is. The posture is the court no longer assumes, it checks. Now, to be fair, because this format always includes fairness, the defense has arguments. Deadlines can be tight. Public figures are targeted. Enforcement units sometimes push for maximal remedies to gain leverage. Courts sometimes correct overreach. And it's possible in this fictional narrative that the moving party timed the notice to coincide with political pressure. That can be true. But here's the counterweight. Even if you believe that, once a court order exists, the deadline is real. The proper mechanism is a motion to extend. If you don't file it, you don't get the extension. Judges treat that as basic. So when the moving party says they missed without seeking relief, that's a procedural red flag regardless of politics. Now we enter the emergency conference at 1:30 p.m. Eastern. The judge, Judge Elena Marquez in our fictional court, opens tight. I need to know whether the deadline was met, and if not, why a motion was not filed. Defense counsel starts with context. The judge cuts it. Yes, yes or no. That moment is always the turning point in these stories. The room goes from narrative to binary. The defense concedes partial non-compliance but argues good faith and imminent completion. The moving party argues partial non-compliance is still non-compliance and asks for immediate enforcement remedies. And then the judge signals the next move fast by doing what judges do when they smell drift. She orders a sworn certification within 24 hours. She orders a narrow list of actions completed by close of business. And she schedules a follow-up for Thursday morning with the warning that if the court is not satisfied, it will expand enforcement. That's the signal, not a final ruling on guilt, a signal about control. Now, competitor scripts also include the expert chorus to make the viewer feel grounded. So here it is in fictional voice. A former prosecutor would say the fastest way to trigger enforcement is to treat deadlines as negotiable. A white-collar defense lawyer would say public statements can complicate legal posture because they lock you into narratives. A former marshal would say, once the court classifies someone as non-compliant, the system becomes mechanical. A constitutional scholar would remind you that process is the court's legitimacy and judges protect it aggressively. The chorus message is consistent. You can fight the case later, but you can't fight the deadline now. Now we widen stakes because competitor scripts always ladder from personal drama to broader impact. Why should you care? Because when a court tightens compliance posture for the powerful, the baseline shifts for everyone. Because if a famous defendant misses a deadline and it becomes a spectacle, other judges become less willing to grant voluntary surrender or informal flexibility. Because prosecutors will cite high-profile non-compliance to argue for stricter conditions in future cases. That's how precedent works, not just in opinions, but in practice. And because political messaging that frames procedural enforcement as persecution can polarize public trust in courts, which has real downstream consequences. But the most immediate stake in this story is simpler. If the court believes family dynamics are undermining compliance, the court will remove discretion from the family and place it in enforcement. That's what rift turns legal overnight means. Now let's talk about the rift itself in the way this format does. Careful, speculative, but narratively clear. The packet references in this fictional scenario that a close family member was approached as a potential character or mitigation witness and did not provide the helpful testimony the defense expected. That refusal or that cool distance becomes a lever for the moving party. They argue it suggests internal awareness of risk, not proof of wrongdoing, but evidence of seriousness. And the judge, who does not care about family emotions, cares about what family behavior implies about compliance. If your own circle is not rallying to vouch for reliability, the judge asks why. That's why courts listen to witness posture in sentencing and compliance context. Now, the political side